5 seconds to go. Start. It is evident that even after submission of police report under subsection 2 on completion of investigation, the police has a right to further investigation under subsection 8 of section 173 but not fresh investigation or re-investigation. It is further submitted that so far as the prayer of the appellant to transfer the investigation to CBI is concerned, as observed and held by this court in catena of decisions, transfer of investigation to CBI is to be done only in rarest of rare cases. Reliance is placed upon the decision of this court in the case of Himanshu Kumar and others versus State of Chhattisgarh and others 2022 SCC Online SC 884. It is submitted that, as observed and held by this court in the case of State of West Bengal and others versus Committee for Protection of Democratic Rights West Bengal and others 2010-3 SCC 571, the power to transfer investigation must be exercised sparingly, cautiously, and in exceptional situations. It is submitted that in the present case, as on the basis of the charge sheet, the trial court has framed the charges, no exceptional case is made out to transfer the investigation to the CBI now. Now, so far as the change in its stand by the state, now so taken in the counter affidavit filed before this honorable court is concerned, it is submitted that as such, before the honorable high court, the state had defended the investigation throughout. It is submitted that just because the political dispensation in the state has changed, now the state has filed an affidavit before this honorable court seeking further investigation in the matter without any substantial evidence, and as such the same is impermissible in law. It is submitted that this honorable court has time and again held that the governments change but the state remains the same. Reliance is placed upon the decisions of this court in the case of State of Karnataka and another versus All India Manufacturers Organization and others 2006 for SCC 683. Now, so far as the chart filed in the affidavit of the state, wherein the state has mentioned previous cases registered against accused number 13 is concerned, it is submitted that the state is trying to prejudice this honorable court as the correct status of those cases have not been presented before this court by the state. It is submitted that out of the said 24 cases, 18 cases have either been withdrawn by the state or disposed of by the respective learned courts. It is further submitted that in a case filed by a lady, accused number 13 has been granted anticipatory bail by the learned court, and the lady who registered the FIR against accused number 13 is herself facing an FIR under IPC and POCSO Act. It is submitted that therefore the allegations made in the counter filed by the state mentioning the previous cases registered against accused number 13 is nothing but a political vendetta, and it is requested not to consider the same while considering the issue in the present case. Making above submissions, it is prayed to dismiss the present appeal. Here the learned counsel, appearing for the respective parties at length. By the impugned judgment and order, the High Court has refused the prayer made on behalf of the appellant to transfer the investigation to CBI, and also refused the prayer for further investigation, re-investigation of FIR number 120 of 2020 on merits, as well as mainly on the ground that once the charge sheet is filed after investigation and the charges are framed, the magistrate has no jurisdiction to order further investigation, re-investigation, de novo investigation. Stop.